I'll just be perfectly blunt. The nonsense that some people put out there just to stir the pot. I'll just be perfectly blunt. The nonsense that some people put out there just to stir the pot. I'll just be perfectly blunt. The nonsense that some people put out there just to stir the pot, that hurts the families all the more. That hurts the community all the more. So use your common sense and trust what's going on. The investigators really are doing the very best they can.
Well, just last night, the Moscow Police Department clarified a statement made by the Latah County prosecutor in which the prosecutor said investigators had reason to believe that one of the victims in the home was, in fact, the target.
Moscow police clarified, now saying, quote, conflicting information has been released over the past 24 hours. Detectives do not currently know.
Early in the morning, Sunday morning, let's say 1:45, 2 o'clock in the morning, something like that. The 911 call didn't come until midday the next day. Does that raise any red flags for you? How do you explain that?
I think the investigators are trying to ascertain why there was a delay and what actually occurred, what was heard. That's a question that's still out there, and I know they're working on that. We're trying to assist them as much as possible with obtaining search warrants for data and cell records and social media and anything that might help.
Do you know who called 911? Can you
Wait,
reveal?
what?
Stabbed to death in 2022, haunting.
Did y'all catch that? Did y'all catch that? Did y'all catch that? Santa letting us know him and Ashley did help with the search warrants, getting that phone data, getting that data.
For you, how do you explain that?
I think the investigators are trying to ascertain why there was a delay and what actually occurred, what was heard. That's a question that's still out there, and I know they're working on that. We're trying to assist them as much as possible with obtaining search warrants for data and cell records and social media and anything that might help.
Do you know who called 911? Can you reveal?
Stabbed to death in 2022, haunting messages from the two surviving roommates giving an unseen look into the moments of the killings. The pair were trying to reach their friends from inside that very apartment that they shared, not yet knowing that they were brutally murdered. Those texts from Dylan to Bethany reading, "No one is answering. I'm really confused right now." Dylan then texting Kaylee Gonsalves, who was killed that night. "Kaylee, what's going on?" Bethany saying, "Yeah, dude, WTF. Xana was wearing all black." Dylan answering, "I'm freaking out right now." Then Dylan pointing out she saw a person wearing what looked like a ski mask. Joining us now for expert insight is News Nation's Law and Justice contributor.
What struck me is, it's not like Hollywood. It's not a scripted thing. It's not like what you would see on a TV set. That was a raw, emotional breakdown of two girls that were scared for their life. There's part of me that knows that, like how that house was. There's a lot of pranking going on. There's a lot of partying. So there's part of them that was probably thinking, is this a prank? Am I getting messed with? I know for a fact my daughter loved pranking people. So my heart goes out to those two girls. I'd have a hard time if I was one of their parents to have my daughter put through what they've been put through. I mean, we sat 2.5 years on what? Why did this need to be hidden from the public? Why did these girls have to be dragged through all this? These are the type of things that why I do these interviews and why we push back a little bit, because I think a lot of people are questioning right now why this was hidden.
Yeah, and from what we can understand.
I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohlberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all of the people who are interested in really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can. As far as Mr. Kohlberger, I can share with you that he is a graduate student at Washington State University and has an apartment residence over at Pullman. He has had an initial appearance in front of a judge in Pennsylvania. He is being held without bond, and the warrant from our magistrate judge here also provides for no bond. We understand that he's scheduled to be back in court in Pennsylvania next Tuesday afternoon, and that a public defender has been appointed for him there. The process at this point is, since he was arrested in another state, he has the opportunity to either waive extradition and return voluntarily to the state of Idaho, or if he prefers not to waive extradition, then we will initiate extradition proceedings through our governor's office. If we do that, it can take a while for him to get here. So again, I'm asking for your patience and understand that's just the way the system works. Once he gets here, he'll have an initial appearance with our magistrate. They'll deal with issues such as making sure competent counsel is representing him, and the case will be scheduled for further hearings. Your primary source of factual information is going to be the court record, because that's what the Supreme Court says we need to refer you to. So please pay attention to what's going on in court and have people there to watch and hear what's being said. As an attorney, myself and my office, we are limited on what we are allowed by the courts to say outside of the courtroom. So please just work with us. Finally, as the chief indicated, this is not the end of this investigation. In fact, this is a new beginning. You all now know the name of the person who has been charged with these offenses. Please get that information out there. Please ask the public, anyone who knows about this individual, to come forward, call the tip line, report anything you know about him to help the investigators and eventually our office and the court system understand fully everything there is to know about not only the individual, but what happened and why.
Don't they know
Cause
that?
and manner of death was homicide by stabbing. Some had defensive wounds, and each had been stabbed multiple times. These murders have shaken our community.
Bill Thompson said the PCA was facts. Ashley Jennings has his back. Check this out. Ashley Jennings has his back.
Address the allegation that the cell phone data was, I guess, purposefully erroneous as to the time that the phone was no longer reporting, which then relates to the supposed position of travel.
Right. Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't understand.
I understand her statement and her argument. I'm trying to understand your response.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By Detective Payne? Or by the cast
information
member?
that he was given from.
This goes to my first question about imputed erroneous statements. So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't.
Right there, that's the question. And Hippler, I believe, gave them the benefit of the doubt. with the suppression hearing, right? But here we are now, tomorrow, April 9th and April 10th, Wednesday and Thursday, big, huge days. And now, based off of that question right there, giving Ashley Jennings the opportunity to answer that, and then believing, what you would do is you would believe the state prosecutors. You have no reason not to believe that they would be telling the truth. And what he is referring to is in the probable cause affidavit, which Bill Thompson said, these are the facts. These are the facts. And in that probable cause affidavit, it straight up says that Brian Kohlberger's phone stopped reporting to the network 7 minutes earlier than truly when it does. This is something that you're not going to be able to get out of. Right there was the question, which is, okay, I don't think there's evidence to show that Payne wouldn't know because Payne doesn't understand it. But the cast expert, Nick Balance, he knows the information. Did he know that what was being submitted on that probable cause affidavit, did he know that it was erroneous? That's the question. And the answer to that question is 100% yes. Yes, the fuck he did. He was co-located. He knew exactly what was going on. And because of the ruling and saying that then that means, how do you want me to rule, as Hippler says, as if one person stands for all, because it was group effort here. If that cast specialist knew, then you're fucked.
I don't think that you have before you a sufficient proffer.
Right there. I don't think you have before you a proffer. Well, motherfucking Cy came up with and entered the fucking doors and laid his dick on the table and said, here's my proffer.
That proves that the cast specialist submitted false information. Apparently there's a difference in the handoffs of 7 minutes. At the end of the day, okay. No, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Well, it's material.
Going a direction different than what your affidavit says it was going, isn't that material?
The direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel.
But that's not what your affidavit says. Your affidavit, in fact, says that the car, like I said, we're not talking about the car here. First of all, you have to talk about the phone. Okay? The cast data, it has nothing to do with a vehicle, you guys. So while she wants to talk about a car, we're talking about data of someone's cell phone that they're missing and buried the 7 minutes of. Ashley Jennings just always wants to talk about path of travel. It's really weird, man.
We're assuming that then the same cell phone, which was then...
I mean, how does this not get a Franks? I mean, she can't even answer this question. You know why she can't answer the question, guys? Because you have to answer by lying. And she's, how much lies, and she doesn't even know how to answer it. I don't even know that answer. Because I got to come up with a lie.
Turned off. Isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohlberger is then found on surveillance. We're not talking...
What? Did you just hear what you said? We have reason to believe that surveillance has the vehicle that Mr. Kohlberger tied. What? There is no license plates on any of these vehicles. Not a single one. This is why you're going to be welcoming in Joshua Hurwitz to the team. This is an absolute embarrassment. But this is an embarrassment because of the trash in. Now this is trash out. The trash in is a probable cause affidavit. The trash out is all the fallout from all the bullshit in the probable cause affidavit. And that's this right here. Trash out.
About 7 minutes. We're talking about 7 minutes at 2:50 in the morning, which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that this 7 minutes, an hour and 10 minutes prior, proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether
couldn't have traveled. Exactly. But that's not what the affidavit says. That's not what your probable cause affidavit says. So when they come back with their argument saying we have all this proof that shows that you buried all this data because it fucked your shit up, okay? Then her answer and her argument is just saying, yeah, but it still doesn't mean that this couldn't have happened, what we're saying here. After that, now that is absolutely fucking crazy, but that's exactly what she's saying. And so tonight we're going to break it down here in 60 minutes. Let's see how good I am at doing this. Okay. So motion limines were filed. Motion in limine.
not the car was pointed in a different direction or not. It's a leap for me. Does that answer?
Well, it's your answer, so.
It's a leap for her. This is Tina with the fuck transition services. What the fuck are you talking about, Ashley Jennings? What's the leap for you? What are you talking about? You're the person in charge of the probable cause. The only thing that's a leap is what y'all did. It ain't even a leap. Okay? It's called prosecutorial misconduct. It's called, I don't know, fucking lying.
Let's say it was.
Oh.
Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included.
Let's say that it was.
It wasn't, but let's say it was.
It was.
Well, the magistrate still had enough information before her to grant probable cause for the arrest.
Well, did she now?
So we still don't get to a Frank's hearing.
Again, welcome to Truth and Transparency. Motion in limine. We are tailgating for the truth. Tailgating for the truth. All right, what is true, what is not true? The state's motion in limine, we're going to start with the 911 text messages. The state wants a pretrial ruling on certain out-of-court statements via the 911 call and the text messages and phone calls of the two surviving roommates to be admissible by way of these exceptions. Number one, the hearsay rule as it pertains to present sense. And number two, excited utterance. So present sense impressions. Now, so the state is asking for a pretrial ruling so that the defense, it limits basically like their sidebars, but it also, big thing with trial strategy. So it's going to, this pretrial ruling the state is seeking. The defense can still object on the record, and that objection would be hearsay. But just to be clear, they would be doing that to preserve the record in an extraordinary way. But it would be automatically overruled based on this pretrial ruling if the judge determines, based off of the oral arguments we will see tomorrow on April 9th and 10th, that the argument is due the text messages and what was transpired on phone calls, specifically one, will it beat the hearsay exception? And personally, for me, this area of the state's case is disastrous either way this order falls. But I think the state should be very careful with, quote unquote, winning this pretrial motion, because I can see a huge downside to winning this pretrial ruling. I believe if the state wins this pretrial motion, the state will then be subjecting Dylan and Bethany to a much lengthier cross-examination on the timeline, their actions, and previous incidences in that house where similar situations have occurred in the past, such as the pranking and who was responsible for those pranks, things that were always going on in their life. But ultimately, based on all of the documents as I read them as a whole, ultimately Ann Taylor and the surviving roommates here, they're going to become third-party culprits like a Jennifer McCabe situation, okay? Consciousness of guilt. So they become third-party culprits by default because of their involvement on some level to, let's say, they know who really did it, or at least one of them, and they're not being truthful. Now, if the state wins this pretrial motion, I believe that the state will jump on it early with jurors in the opening statements by casting Dylan and Bethany and their communications and being the reason that the state was able to get justice for their best friends and roommates. The state knows that it will be heavily relying on Dylan and Bethany's text messages and interactions in that early morning hours to set the time of the crime before 4:20 a.m., but yet after 4 a.m. Looking at the cameras and surveillance then around the area, they were able to zero in and focus in right away at that 4 to 4:20, 4:30 time frame. Now, how I was able to narrow this down is based on the argument for the state. They say that DM's phone records contain an Exhibit S for the November 13th and BF's testimony as to what DM told her should be allowed at trial. So what happened at the grand jury is that Bethany was able to testify to what DM said to her on the phone. And that comes in the way that the state then presents it. And so the state wants what Bethany claims DM said to her on the phone call at around like the 4:19 and 7 seconds or 4:20 time frame to be admissible. The state is saying that this is all admissible because there was no time for reflection and fabrication. All of the above declarations are present sense impressions and excited utterances. This is supported by DM's grand jury testimony, where she indicates that she just witnessed a startling event. The declarations indicate that both BF and DM are trying to make sense of a startling event contemporaneously or immediately following the startling event, which means that there was no time for reflection, no time to fabricate. Ann Taylor says, not so fast. Ann Taylor fires back and says, with her argument being that the completeness of the evidence is important, it's needed for context, and it is missing from the way that the state has clipped in the way that they did the grand jury proceedings. This is not the grand jury, okay? And so Ann Taylor fires back by including what happened prior to the time that the state wanted to start their argument. And Ann Taylor heavily relies on the word trustworthiness. Although the rule does not expressly state, factors of trustworthiness and necessity play a role, a large role, in a trial court's decision whether to admit a declarant's expression of his state of mind or whether to exclude it. Ann Taylor makes it very clear that the time of the crime is most certainly disputed. And this is the first time I'm going to say it. And it's happening on this preview live for tomorrow, and Thursday's amazing coverage is ready for it. Ann Taylor is going to be, no doubt, when you take all of the motions as a whole, Ann Taylor, in my opinion, is going to be arguing that we are heavily in dispute of what time this crime happened. We are not in agreement at all that they want to say that this time of crime was from 4 to 4:20, 4:25. So I believe that Ann Taylor is going to suggest, and she does it, that she ties this kind of in with the alibi motion. But Ann Taylor says that both exceptions require the statements to be contemporaneous with an event and be spontaneous without time for reflection. In this case, Ann Taylor says that the rule of completeness is critical, both to analyze the claim of an excited utterance and to understand the context of what was occurring. Mr. Culber has maintained his innocence. Thus, the time frame the state alleges is very much at an issue. Now, when Ann Taylor fires back, that's the first time that we then see, because Ann Taylor is saying that, listen, Judge, the state has claimed that Dylan Mortensen was asleep basically from 2:10 to when she was awoke at 4. That's not the case. We have DM up at 3:51. Okay. We have, why do you think she introduced the 2:10 text to EG and the text back at 2:13? Those were included for a reason. And then they include a shit ton of more transactions, you could say, because the state says that DM called BF at 4:19 and 7 seconds, but the defense says that BF called DM. So who has it right when you go and you compare the two motions? I don't know if you guys have caught that yet, but did DM call BF or did BF call DM at 4:19 and 7 seconds? DM says that her phone is about to die, but plows through like a champ on that phone. I would love to know if Josiah Roloff checked the battery life to see if it was plugged in. Ann Taylor says the second grouping of messages that the state claims fit within this exception of the hearsay rule are from those from DM to her roommates beginning at 10:30 or 10:23. This is so important because what the state is alleging and what they alleged in the grand jury is that DM had just woken up at that point, realized that, oh wait, my roommates didn't get back to me. And the state claims that DM woke up and realized her roommates had not responded to her earlier text. The state is wrong. DM was awake. She was messaging on Snapchat. She was on Instagram. She was texting with her dad. And this is not an exhaustive list of activity on her phone. The proffer, as Ashley Jennings wants to talk about proffers, Ann Taylor then comes through with her, who is a very, 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 very special and very highly sought out forensic examiner, digital forensic guy, Josiah Roloff, comes through, lays it down, and he has lots to say of what was going on, deleting, manipulating the phones. So of two phones that he had taken a look at. So the state believes from their evidence that DM fell asleep between 2:13 a.m. and 4 a.m. because there was no phone activity. And then boom, all those texts and calls happened and it was all present sense impression. The defense is saying the state is relying on faulty evidence, incompleteness of the evidence. The defense then shows the judge here in this case, now past the grand jury here, that DM is not asleep like they claim. Defense clearly wants to make EG relevant, and adds that exchange as well as a contact being saved at 3:51 a.m. The state is basically saying that there could not have been plotting or planning between 2:10 and 4:19 a.m. prior to anything going on because people were sleeping. Now, Ann Taylor is basically saying, hold up, stop, you're wrong. They weren't sleeping. DM wasn't sleeping. She doesn't make any mention about BF. So yes, the fabrication began with the calling and the texting. What if that's what's fabricated? The white Elantra don't matter if the crimes are before 3:30 a.m. Is that right? Nothing would matter of what was going on any camera between 4 and 4:25 if the crimes didn't happen. Now, Lana, how can you say that you're so sure on that? Well, it's because then I would ask all of you guys to turn to the state's motion limine with the alibi. What Ann Taylor comes back with is my reasoning. Ann Taylor is saying that, so we're moving on. Here's the next thing that's going to be the motion limine. I'm pumping them out. I came typed up and blazing. Everything, all those papers, now just this big. The alibi defense. The state says that Brian's disclosures do not meet the rule. The defense is saying it's a partial alibi. And they waited a very long time to get the phone records because we were waiting on you because that's Brian's alibi that we have to give to a expert. Okay? So with that said, though, the state says that the defendant has failed to comply with the rules and the requirements of Idaho code, right? The defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of witnesses. Keyword there, alleged offense and the alleged time. Well, what time is this alleged offense to be at? 4 to 4:20, right? Well, what if you're a defense attorney and you believe the time of the crime is at a different time? And because you have evidence to believe X, Y, and Z based on the discovery, based on poor investigative skills, okay, we have evidence to believe that the crime is at a different time, and our partial alibi is this. Ann Taylor answers the motion and says, partial corroboration does not cover the time alleged in the state's charging documents or in any affidavit in support of searching and seizing Mr. Culber's person and property. Partial corroboration relates to where Mr. Culber was during the early morning hours of November 13th, 2022. I thought about that for a long time. To suggest that Mr. Culber is hiding a witness that will prejudice the state, that is simply not the case. Let me break it down for you. He will use information contained in the discovery supplied by the state, and he will present the testimony of expert witness Cy Ray. And this is where I then am saying my opinion, like about 5 minutes ago, that the crime happened earlier and that my client has an alibi during that time. You guys can say that this crime happened from 4 to 4:25. That's awesome. We believe that the evidence says otherwise. And if that's the case, right, then it's all coming together. When you look at the motions and the way they're presented, that the crime was earlier and Cy Ray has his locations earlier. Alternate perpetrators. What is Ann going to present? This is her chance. What is Ann going to present that creates third-party culpability? Shit, once I saw that in the Karen Reed case, due to Jen McCabe having a deleted text message, house long to die in the cold at 2:27 on her phone, before the bodies were found, or before John's body was found, right? And freezing in the cold, right? Alan Jackson listed Jennifer McCabe and and Brian Albert in that case as third-party culprits. The body was found on Albert's lawn, and Jen clearly had evidence of consciousness of guilt with the text message or with the Googling. So that then brings me back to, what were the roommates doing? No, Lana's not saying that the roommates killed anybody. I don't think that Jen McCabe killed anybody, right? But do I think that after the fact, Jen McCabe learned of stuff? Absolutely. But do I even think that Jen McCabe was the author of and using the phone that night? No, I think it was her husband. Anyways, what is Ann Taylor going to present that creates third-party culprits? Are we going to hear names in this hearing? Are we going to hear evidence that ties those same names to the crime scene? Are we going to hear that the roommates, or at least one of them, played a role in possible knowledge of something other than what she told police and testified to at the grand jury? Are we going to hear that the quote-unquote police cleared people too soon based solely on receiving the tip, which was the name of Brian Koberger? There was no other way that these people weren't ruled out. These people were, just because the name Brian Koberger was given to them, it does not negate everything up until that point that they had on those people. If Brian Koberger wasn't linked to the sheath, as Payne said when he gave testimony that he didn't know what the FBI linked, or the name Brian Koberger was just given to him. If he truly did not know that, then why was he uploading only the sheath profile to CODIS? He would have to know it by process of elimination, because the other stuff, according to him, wasn't uploaded to CODIS. It's a big flaw there for Payne right there, and Ann's going to attack that. As Payne said, he did not know what it was that the FBI was linking him to. Well, then I'm saying, then wouldn't there be a lot of dead ends if Payne was doing a quote-unquote independent investigation based on the fact that Brian Koberger, this tip being unknown as to how it is even relevant to the case? If Payne knew it was the DNA on the sheath, then any good investigator would say, hey, Brian's ties stop there with the sheath. There's no link to the victims. You know, you're going to be going down your, but that does not negate anything else. Meaning the people that were third-party culprits, or the people that were actually the culprits before the name came up. Is Ann able to argue that the ones in charge of this investigation bolstered its case, which was only the touch DNA, that they bolstered the transfer touch DNA by erroneous path of travel with a vehicle and a phone? Are we going to hear possible multiple weapons leading to multiple perpetrators? How about, is the perpetrator right or left-handed? We know that there's blood evidence is not linked to Brian Koberger. Who does it belong to? Could not have been done by one person in the amount of time that the state is claiming. Next, we have stipulations to the inflammatory statements by both sides. I believe they came to resolution with that. I am very super interested in how the ruling is going to come down on the deadlines that were not met by the state. I believe that is procedural due process. There's going to be a violation. Okay. For Brian Koberger to get his witnesses, his expert disclosures in before the state's expert disclosures, that's procedural due process violations, in my opinion. It's a problem. I'm very interested in hearing about basically what Ann's saying is that, hey, the lab experts, whatever lab expert did whatever, they can testify to just their report. They're not going to be testifying to other people's reports. And the biggest decision with the experts is going to come down to Nick Balance being considered an expert in this case. Nick Balance is the Ashley Jennings. She can't split it out. She can't talk about this cast. That's going to be Nick Balance. Nick Balance and his ability to offer up expert testimony in this trial after not submitting a report with any opinions or methodology. Next. Now, motion limine 5 and 14 for the defense. It comes from the same, it's from the fingernail of Maddie Mogan. Number 5 is off of the inconclusive data part. And the 14, the number 14, because they listed them 1 through 14, and that's the statistical analysis. And what the defense is saying is that we want it all in, but we're not going to allow Ashley Jennings or Santa Claus to ask questions that they asked in the form of question, the way that they worded questions for the grand jury. So the court should exclude questions and testimonies such as that described above, which is here expanding beyond the language of the report would prejudice Mr. Kober, and that it might allow the jury to infer that the inconclusive data would mean that he might be included. And then the statistical analysis, again, keeping it to the report. So the defense is asking that the court not allow Ashley Jennings to ask questions like this to Jada Miller. Remember that the fingernails of Madison Mogan, they have basically 3 people. Next up, transfer touch DNA. What can the wording be used? I believe that they're going to give this to the benefit of the doubt of just, we've never limited how a person could say touch or transfer or trace. But to me, it's just to hone in on the fact that you're not going to talk about how something got there. Next up, IGG. IGG. Whew. Let me get my sip in here. Whew. Before I say IGG, want to say that my prediction here, whether it happens tomorrow or on the 10th, Mr. Cox for Amazon and Mr. Douglas for Amazon, they've never testified in any capacity to this. So I'm interested to hear Ann argue that about this Amazon clicks. Detective Gilbertson testifying to doing a test run of how long it would take to commit these murders and not taking any notes or videos of this and just counting out in rooms. I mean, that's wild. It's absolutely wild. It's going to get denied. It's not going to be able to be in. Because Ann's argument should be is that we're not just talking about getting in and getting out. The state's case is you got a guy in a different state. He's got to get out over here in this car at these times, do all this shit, be seen on these cameras, doing all of that. So to me, it's all of that. But they didn't take any notes. They didn't record their experiment. The house isn't there anymore. When the defense asked for this discovery back in 2023, they said it didn't exist. There is none. Well, then, sorry, you're not performing a fucking an experiment or without your methodology is so flawed. How can you reenact that out with one person? Flawed. Mowry, Tanzola, and Urig. These 3 people are the digital forensic people that would take a phone and, after the extraction, and they would go and map it out a timeline and give you a pattern of where everybody went and whatever person you were in charge of, shit like that. Nothing has been turned over Not a single thing as far as opinions, a report, nothing the state has to hear. This is what these guys are going to testify to. They're considered experts and how everything played out. 68 devices, digital devices, none of them in a report in some capacity where you're plotting, down the movements of the victims. You're plotting down Brian's movements and where he's been and bopping around the 3 months leading up to, when he moves over from Pennsylvania to Washington, and what his pattern and where he was ever at the same time that the girls were, things like that. For an expert's opinion and for the jury then to hear that this person's an expert, right, that holds weight. You have to get and disclose that ahead of time. And then the defense has their experts to combat that shit. And then there's rebuttals. None of this played out in this procedural way. And so, and even after the fact that it didn't, they still have no, I don't understand that. I have no idea how that's possible. And then FBI agent balance is that big one for me. Okay, IGG, here we go. The state put theirs in first and said, hey, this is why we want the IGG out. We want it out because, or this is how they presented it. The state respectfully moves the court to order in limine for an order of one, that the defense cannot describe the extent to which the parties can refer at trial to the investigative genealogy and how it's used in this case. We need the courts to tell us how we are able to talk about this. Okay. Number two, we're asking for an order for you to exclude from the trial any testimony or evidence related to the United States Department of Justice interim policy. Okay. Why this is important and why the state's asking for it to be out at the time. We can't have, they said it's going to be over prejudicial for them. Well, my argument back is, well, isn't bad evidence always prejudicial? It's not overly prejudicial. It's prejudicial just because it's bad evidence against you, but not that it's inadmissible. The FBI did all the work in this case. The Moscow Police Department, the Idaho State Police, they were the lackeys. They were like, okay, you're not going to, it's your jurisdiction. We're doing everything, basically. And you guys are just the pencil pushers in a way. And then you bring in Ashley Jennings and Bill Jennings, and that's what they were doing too. Fuck, they were doing search warrants for them. So there's no mention of the DOJ policy and that the FBI violated the DOJ policy. And that the last thing is that we don't want any talks about the terms of service for any of these genetic genealogy subscription services, that we violated the terms of service, the user policy. Great, awesome. That's what the state wants. And the reasoning for wanting it is to say that, well, let's back up. When I was reading this, I said, geez, imagine that. The jury is just supposed to believe that all these guys in law enforcement are just all on the up and up, that all of them are trustworthy and nothing, like they would never do anything, outside of the box. Insert Nick Balance, insert the PCA. Those are the FBI people. But the biggest thing that came from this motion is, and it should drop everybody like this. In this motion, the state says, and they just come out and say it, and they slap Hippler across the face. And they say, the name Brian Culpability first appeared on law enforcement's radar in this matter because of IGG. They just put it in a sentence just like that. I just read it. They oral argued in a suppression hearing for Frank's hearing. as well as multiple suppression hearings, that is not true. They said that they let the judge believe that PCA is how they got to Brian Koberger, and that the tip is just the tip, and then we still independently investigated to confirm, the guilt by going and getting the DNA. But here, for the first time, the state says the name Brian Koberger first appeared on law enforcement's radar in this manner because of IGG. And IGG has been the subject of much litigation in this case. So they just told on themselves. Most recently, the court found the use of IGG during the investigation did not violate defendant's Fourth Amendment rights. Well, guess what? If you would have told Judge Hippler that if you would have told Judge Hippler just the first sentence, though, that that's truly how you got to him, then everything would have been suppressed because all of your search warrants are fucking erroneous. So how do you go back and fix this? Can you think about that? Think about, we have a trial. Girl's up for murder. She's acquitted. She comes out next day, grabs a mic and says, guess what, motherfuckers? I did it. I killed that motherfucker. Double jeopardy, you can't charge her. Right? This isn't double jeopardy, though. So the judge now knows that he was lied to. So how is Ann Taylor going to use that sentence that came out in this motion, where the state then admits that in the order the Judge Hippler said X, Y, and Z, and it was lies, and they knew it was lies. And that's prosecutorial misconduct. The state's view from the outset has been that the IGG information was nothing more than a tip and was never intended to prove or substantiate defendant's guilt. It was never intended to prove or substantiate defendant's guilt. If the only reason you have Brian Koberger's name through IGG, right, then yes, it was used to substantiate his guilt when you went and obtained his parents' motherfucking DNA out of the trash of his home in Pennsylvania. Because what did you compare it to? The DNA off of the sheet that you used for the IGG. I mean, how can you not say that that's how the circle worked? You just admitted to it. I've never heard of anybody being able to offer up a tip after they take a piece of evidence from the crime scene to use to then develop this tip and lead to then give it to you. Have you guys ever done that in a case? Have you ever heard of any of the, citizens out in the world just walk along like, hey, yo, if you give me, if you give me that so-and-so, I can get you a tip. Evidence from this case developed that tip. Why not just use it the PCA? You should have. Don't know why you didn't. Oh, that's right. Because it comes to the first thing that you wanted to have ixnayed here, which is we don't want you talking about at trial about us violating the justice policy, the DOJ. The state says that if you allow this, then this case is going to become something that it's not supposed to be. And I said, when in the world have cases not been about somebody's character? You believe somebody's work and what it produces, okay? Because they're ethical, because they're credible, right? If you hear about things that make somebody, I'm unsure now, yeah, that's a problem, right? So I got some cahoons asking but guess what? At the end of the day, Ann Taylor and her team said, We want the IGG out altogether. Wait, what? Yeah, we want the IGG out, gone altogether. And then they list and they show that in this IGG motion that then the defense put in, it said, based on the testimony of Michael or Matt Gamet or whatever his name is from the lab, you guys had everything that we were looking for and you didn't disclose it. So we have a Brady violation right now. And because of all of this, we are now asking that the IGG cannot be used at all. And then in comes the state and they're like, wait a second, we don't want it to be used either. So this sounds like a great deal for us. But hey, wait, we didn't commit no Brady violation, okay? Like these were all just inverted. Inadvertently, they weren't uploaded. Sorry. Well, we needed those to argue our point at the suppression hearing. And you withheld the SOPs, the standard operating procedures. You had them. You knew that you had them. But why does it matter? Who cares? The SMPs don't care, or SOPs don't care. It's like, what? Then why were you so fucking hard up to not turn them over? You want to know what the SOPs showed? The standard operating procedure shows that all of this stuff was supposed to be preserved in the chain of custody. And you wanted to bury that. I was on the phone all day today talking to lab personnel people and asking if somebody was trying to keep standard operating procedures from you, what would you think about that? That's unheard of. Really? Wow, I want to hear more about that. That's the only way that you can validate things. Now, when I found out that the state provided test results in the forms of 2 large text files, one identified as being the data produced by Othram and the second as the data produced by the FBI. Still not having received the promised material regarding the SNP testing conducted by Othram, Mr. Culber renewed his request for the material in his 15th supplemental discovery request and filed his 5th motion to compel discovery. A hearing was held in Latah County District Court on May 30th, 2024, during which the state reiterated that Mr. Culber was entitled to the requested material. And that's when all the stuff got buried. At the end of the day, the defense is saying, we want the IGG out. And then the state's like, well, so do we. So we agree to this. We agree. The IGG's out. We just need the judge now to let us have a sanitized, washed down way to tell the jury on how our investigation progressed. Do you guys know what that means? They are asking Judge Hippler to allow us to lie to the jury on how we got to Bryan Kohberger. Because we can't really, because of how we told you guys we did it in the PCA, that's not really what we did. So now we need the judge here in this motion to limine to say, we just need to be able to say that an investigator, okay, received a tip, and that's how we got onto Bryan Kohberger's name. And then incoming, the defense says, if you're suggesting that you're going to give false material or elicit false testimony on how you got to Bryan Kohberger, we're asking the judge, we welcome the argument. We welcome this argument at this motion limine. So we are going to be arguing now for the first time. Thank you so much, MAGA, Monica. Is that it? $200 super sticker. Woo! RV in it, baby. Super sticker. $5. Sunny Days became a new member. Lenore bought 5 Truth and Transparency memberships. Papa G, inverted, gifted 5 Truth and Transparency memberships. Noel. We don't even know that answer, Noel. Thank you, $4.99. Gifted Truth and Transparency membership. Thank you so much, Marsha. The text to the private driver asking if he was still out driving was the building blocks of an alibi. Maybe. Motto. And Carol D. Carol and D. Thank you, guys. Thank you. So for the first time ever, we're going to hear an argument that we've never heard before. In my opinion, I don't think we've ever heard one, where the state is going to ask for a judge to write up an order, allowing us to use an investigator and talk about how we developed this lead of Brian Koberger without mentioning the IGG. And now the defense is saying, well, Judge, we welcome this argument because here in its own motion, they make it clear when they say the first sentence, they have the audacity to say that the name Brian Koberger first appeared on law enforcement's radar in this matter because of IGG. And IGG has been the subject of much litigation in this case. We've lied to you for the past 2.5 years, Idaho, is what the state is going to be saying. And now we got all the way to this point, the motion to limine, and now we need you to allow us to tell the jury something that's not true. This is why I believe Josh was on the case. My personal opinion. I don't believe that Ashley Jennings or Bill Thompson are worthy to represent the victims in this case. The victims in this case deserve more than Ashley Jennings and Bill Thompson. The families deserve more. There is no way that you are talking about this case and being able to say that you got to Brian Koberger without using the IGG. It's impossible. And Ann Taylor made it bulletproof when she put on the stand Detective Payne. And then they made it bulletproof, the state did, when they admitted in the filing. And then now Judge Hippler, he knows that he was lied to. What's he going to do? We have witness identification about the bushy eyebrows. This all goes to time of the crime, guys. This all goes to time of the crime. This all goes to truthfulness. This all goes to reliability in the terms of if Dylan was not being truthful in other aspects of her statements to police, then how is this reliable? That's how Ann Taylor is going to be attacking that. She has the backing of Josiah Roloff in his findings. Okay. It's all right there. I've gone over it till ends. Make and model of the suspect vehicle. Ashley Jennings, for whatever reason, the make and model of the suspect vehicle has nothing to do with path of travel. And she wants to combine the two. I don't know why. I don't care why. She's wrong. I have no problem going toe to toe with her and fucking telling her to her face if I ever had the opportunity. She's absolutely wrong. She looked like a complete fucking fool on January 23rd. And that was before Cyree threw his dick on the table. Once Cyree laid it all out there, she needs to pack her bags. The make and the model of the suspect vehicle, they lied about what camera did it. The camera that's right next to the house where the crime scene is, that was not the camera that was used to identify a white Honda Elantra. That's going to come out tomorrow, or the 10th, depending on the order that they go. The path of travel has nothing to do with that motion in limine. And Taylor wants to make sure that Detective or Special Agent Immel is strictly staying to his report. And it was never testified or never written up that it was a suspect vehicle. He was given footage on different days. He never compared the one day to the other day in any of his opinions. And he always labeled it as a questioned vehicle. And then in come the AT&T timing advanced records. I mean, this motion in limine, where we're going to have our little breaks and recess, there's bomb after bomb after bomb after motherfucking bomb. There's not going to be a break tomorrow or Thursday. I mean, these are huge decisions. But the way that they kind of all tie in together is, for example, Nick balances timing advance. Did he use them? Did he not use them? Did he have them? Did he not have them? The state's case could potentially be these are some serious allegations. And I have no idea why mainstream media won't talk about it. But then I said, you guys hear how quiet it's been? Why isn't anybody talking? I mean, tomorrow's such a huge day. Who's talking about it? Who's talking about the fact that there's two huge motion limines? It's one big hearing, but it's 2 days, and there's hella shit that's on this docket for tomorrow and the next day. Who's talking about it? When mainstream media is quiet, that's when you know there's trouble in paradise. And when I'm talking about paradise, I'm talking about the government. Who has yet talked about the huge, huge, huge allegations? You guys, it is a fact that they buried 7 minutes. Right there, that clip, I put it in there in a reason. I put this in here for a reason. Right here at the end of this, Ashley Jennings looking like a complete fucking idiot.
Isn't then also tied to the evidence where we do have information to believe a white sedan tied to Mr. Koberger is then found on surveillance. We're not talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning which is about an hour, approximately a little over an hour before the crimes occurred. I don't follow the logic that...
I don't follow the logic with why you're talking about the car when we're talking about the cell records, the towers, the handoffs. The question is, did this detective know Did he know that it was faulty, that you guys relied upon shit as facts? And the answer to that question is yes. Yes, he did. You want to know how I already know the answer to that question is yes? Because of Judge Hippler's order already. Judge Hippler ordered that the guy he said clearly, the Moscow Police Department officers, they got the information from the FBI guy. It was written in the report or in the order. That's Judge Hippler's order. That clearly Payne didn't, fuck this up. Well, then come to find out, I don't even believe that Payne wrote that up. I believe that Ashley Jennings did this. I believe that Ashley Jennings is to wholly put a shit ton of stock in, and that she pushed this probable cause affidavit to be the way that it is. Who at the end of the day decides to prosecute somebody? Who at the end of the day brings charges on somebody? It ain't the fucking cops. It's the fucking prosecutor that's going to say that I'm going to prosecute you. You learn that on Law and Order.
This 7 minutes, an hour and 10 minutes prior, proves that there's no way.
It has nothing to do with the 7 fucking minutes. You wrote on a piece of paper that the phone shut off at a time that it did not, Ashley. You wrote that it shut off at a time that it didn't. And it was co-authored by everybody there. And it was specifically asked, and it was testified to by Payne, that Nick Balance had a copy of the probable cause affidavit that went with the timing for the, not the timing advance, but for Brian Koberger's December 23rd call detailed records. That he had a copy of this, so he knew what was in it, and he had a copy of the actual search warrant. This all came out in earlier testimony. All of that stuff is always in play. There is no walking that shit back. So either Detective Payne and Mowry can say they lied, right? And that, no, I did it all myself, and I knew, Detective Balance told me that it wasn't. But see, then they're still fucked because but Detective Balance was the one that got it and saw this, that they actually went ahead and did put that in, and he still let it go through. There is no way around this. The bombs that are going off in Boise, Idaho tomorrow are every big case that's going on right now, take every huge bomb that's gone off in those cases and put it all together, and this is times 10. This is the biggest case of the century, and this is how these motherfuckers did this case. And if I was Steve Gonsalves, who I said I love him and his wife, but this shit, they do this shit with my kid's case, fucking rage on this motherfucking shit. This is who I'd be owning that town. I would sue the fuck out of these people. Lying to you, lying to your family, lying to your community. If Brian Koberger was the guy, then nobody was safe in that town.
The defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not. It's a leap.
The car isn't GPS, you dumb bitch. The car isn't the GPS system. The GPS and the towers are on the phone. And anybody that testifies as an expert always tells you that. We are talking about the device. So she goes to this car when we're talking about the towers. It's absolutely absurd. She doesn't know what she's talking about. Or does she? And she's just trying to spin and gaslight this motherfucking Hippler.
For me. Does that answer?
Well, it's your answer, so.
I'll just be perfectly blunt. The nonsense that some people put out there just to stir the pot, that hurts the families all the more. That hurts the community all the more.
It sure does, Bill. Woo! Welcome to the transparency. We're going to be live all day tomorrow, all day on Thursday. Really quick, what do you guys got in chat? I think I hit all in my quick 60. What do you guys got? Right here, I had to go with the old school, hit up Bill. This is back in the day. I put this video out when this is a brand new video that I made, but this right here, Bill saying right here, this is classic right here. Cheers, Bill.
I'll just be perfectly blunt. The nonsense that some people put out there just to stir the pot, that hurts the families all the more. That hurts the community all the more. So
all they did was put out nonsense.
And
use your common sense. Use your common sense. Wow. Rich coming from you guys.
To trust what's going on. The investigators really are doing the very best they can.
Well, just last night, the Moscow Police Department clarified a statement made by the Idaho County prosecutor in which the prosecutor said investigators had reason to believe that one of the victims in the home was, in fact, the target.
Moscow police clarified, now saying, quote, conflicting information has been released over the past 24 hours. Detectives do not currently
early in the morning, Sunday morning, let's say 1:45, 2 o'clock in the morning, something like that. The 911 call didn't come until midday the next day. Does that raise any red flags for you? How do you explain that?
I think the investigators are trying to ascertain why there was a delay and what actually occurred, what was heard. That's a question that's still out there, and I know they're working on that. We're trying to assist them as much as possible with obtaining search warrants for data and.
Right there, Bill admits right there in front of all of your guys' faces, in case you didn't catch that part, we're trying to help them all that we can. We're trying to obtain search warrants for data. He's letting us know, like they were doing these search warrants. Ashley Jennings wrote up the fucking search warrant, got the information from Mowry saying, hey, make sure you put timing advanced record, write that in the search warrant. Bill tells us it right here. Motherfucking witnesses. Put them on the witness list, and
cell records and social media and anything that might help.
Do you know who called 911? Can you reveal?
Stabbed to death in 2022. Haunting messages from the two surviving roommates giving an unseen look into the moments of the killings. The pair were trying to reach their friends from inside that very apartment that they shared, not yet knowing that they were brutally murdered. Those texts from Dylan to Bethany reading, "No one is answering. I'm really confused right now." Dylan then texting Kaylee Consalvis, who was killed that night. "Kaylee, what's going on?" Bethany saying, "Yeah, dude, WTF. Xana was wearing all black." Dylan answering, "I'm freaking out right now." Then Dylan pointing out she saw a person wearing what looked like a ski mask. Joining us now for expert insight is News Nation's Law and Justice contributor.
What struck me is, it's not like Hollywood. It's not a scripted thing. It's not like what you would see on a TV set. That was a raw, emotional breakdown of two girls that were scared for their life. There's part of me that knows that, like how that house was. There's a lot of pranking going on. There's a lot of partying. So there's part of them that was probably thinking, is this a prank? Am I getting messed with? I know for a fact my daughter loved pranking people. So my heart goes out to those two girls. I'd have a hard time if I was one of their parents to have my daughter put through what they've been put through. I mean, we sat 2.5 years on what? Why did this need to be hidden from the public? Why did these girls have to be dragged through all this? These are the type of things that why I do these interviews and why we push back a little bit, because I think a lot of people are questioning right now why this was hidden.
Yeah, and
why this was hidden? I'll be blunt. Ready? It was hidden because of all the deletions and the phone manipulations that were done by user hands. This wasn't TikTok running on a whatever. This is a digital forensic senior analyst is going to come in and show what the hell was deleted from these phones, what the phone calls were, what was truly going on. And when you want to talk about staging something, when you want to talk about the argument for Ann Taylor here, it's very simple. The state is looking at this hindsight back over here, but wait, if you extend this up and you look at we're asking you to look at the whole timeline. We're asking you to look at the whole timeline. And no, we don't believe that these people were sleeping, because that's not what the phone says. And the phone, in order to be doing what it was being operated by manual commands. That's why this shit was hidden. So yes, Moscow Police Department was protecting the surviving roommates. They were, and they were protecting them at the grand jury by sanitizing and shaping and forming this little present with a bow on it in testimony that was not accurate. And in fact, was it known to be deceitful? We're going to find all of this out tomorrow and the next day. I think people are in for a rude awakening.
From what we can understand.
I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohlberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time,
all right, guys,
we
peace out. Good night.
expect that affidavit and cell records and social media and anything that might help.
Do you know who called 911?